just in the interest of time, we'll go ahead and get started. Thank you all for being here. My name is Yusef Wyndham. I'm the 1L representative of the International Law Society. So thank you for coming to the event. We'd also like to thank the JDLLM program for co-sponsoring this event. Today, Associate Professor Barbara Koremenos is going to discuss her paper, If Only Half of International Agreements Have Dispute Resolutions, which half needs explaining. Professor Koremenos is currently a political science professor at University of Michigan. She received her PhD in political science from the University of Chicago in 1999. She also received a master's in public policy from Chicago in the early 1990s. Much of her research applies game theory to issues of institutional and agreement design. She has published in International Organization, Journal of Legal Studies, and Rationality in Society. She is co-editor of a special issue of International Organization, published in fall 2001, entitled Rational Design, Explaining the Form of International Institutions, in which she co-authors a theoretical framework article as well as the conclusion. She is the second political scientist ever to receive a National Science Foundation Career Award in the amount of $250,000 for her project entitled Designing International Agreements, Theoretical Development, Data Collection, and Empirical Analysis. So help me in welcoming Professor Koremenos.
Thank you. I'm very impressed you pronounced my name. You got it. That's I'm just so used to it being mispronounced. I don't usually notice anymore. I care about the spelling, you know. But I'm very happy to be here, and I'll get started. I'm very happy for this opportunity, especially to present in a law school, because I say I do international law, but I've never actually had a law class. So I need to sort of expose myself to a crowd like this and get challenged in that direction. I'll talk for about 30 minutes, most likely, and then take questions. But I am from the University of Chicago, and I'm used to being interrupted. You know, usually you put up your title and you already start getting criticized there about why that's the wrong paper. So really, go ahead, and I will reserve the right to put off your question. But if there's anything, clarifying questions or whatever that you want to ask, feel free. So the title and the whole project, I'm going to tell you a little bit, put it in the context of this larger project that's sponsored by the National Science Foundation on designing international agreements. So this is just one tiny little part of it. But I think I was invited to a conference, I believe at the University of Chicago Law School, on dispute resolution. And so I was collecting the data, but I hadn't been focusing on that aspect at all of my data. That's not what my first sort of set of articles was about. So I just generated the descriptive statistic, and it was this. And I looked at sort of the other papers at the conference, and they were basically kind of all focused on NAFTA, the EU, and especially the transformation of the political negotiation style of dispute resolution under GATT to the very formal legal process under the WTO. So this is a very hot topic, and it's getting a lot of attention both from international lawyers and international cooperation scholars. And it's an important topic. I would go so far to say as the more that states can use institutions to adjudicate or arbitrate their disputes, the more international law resembles domestic law. Okay, and right there, that's a debate in both fields, I believe. But while a lot of attention has focused on these three cases, we don't have a very good idea regarding what the typical international agreement entails with respect to dispute resolution provisions, okay? Our intuitions about international dispute resolution and international cooperation more generally are shaped only by a few high-profile agreements. Okay, almost all scholarship is focused on case studies. In reality, institutionalized international cooperation is captured in the more than 50,000 agreements that are registered with the United Nations. Indeed, most cooperation is bilateral, and has as its foundation an international agreement, not an international organization. So what kind of picture emerges if we consider this larger continent of international cooperation? And that's actually the motivation for my broader National Science Foundation project. That a lot of these agreements, if you are picking randomly from these 50,000 agreements, some of them you might think are trivial, but taken as a whole, this is, I believe, you know, a strong argument can be made that this is the best way to sort of capture what's going on in day-to-day international cooperation, international law among states. So I look at a random sample of international agreements conditional on 4 issue areas: human rights, economics, security, and environment. So this is, I believe, the first study that sort of cuts across these 4 major issue areas, which makes it exciting, but also extremely sort of, I'm pulling my hair out a lot because it's very difficult sometimes to compare across issue areas. It's kind of like comparing apples and oranges. And so trying to figure out exactly how to do that and to do quantitative work is a challenge that I'm still really trying to rise to. But if we look at this random sample across these 4 issue areas, that's where we get this statistic that only half of them have dispute resolution provisions. Now, I'm kind of, you know, obviously a geek. I'm a political science professor. So for me, this is the kind of observation that begs for an explanation. And if I can sort of caricaturize the fields a little bit, which half needs explaining is going to depend on where you're sitting. So the standard international relations perspective, especially those, you know, realists out there, are puzzled why half of international agreements even have dispute resolution provisions. Okay, because international agreements don't really make much of a difference. International law doesn't really have any effect. It's just kind of cheap talk. So why should states bother putting in dispute resolutions in half of their agreements? Don't know how the Duke International Law crowd feels, but the sort of more traditional international law crowd would kind of be puzzled, well, why do only half have dispute resolution provisions? Why not all of them, okay? So one way of getting perhaps some leverage on this puzzle is to ask, well, what happens when states have a dispute and there is no dispute resolution provision? Because that can happen. Well, there's the ICJ, right? It's kind of the default court that's lurking in the background. But to have jurisdiction, both parties to the dispute must agree. So it's not really clear whether that, you know, international law or international realist kind of perspective is more compelling. Obviously, you know, the goal here is to do as systematic, theoretical, and empirical work as possible to kind of get some answer to this question. And so the first thing is to look to other fields for guidance, right? And if we look at comparative law, there's a lot of great work there, and we see that they analyze and compare a set of relatively long-lived institutions like domestic courts. And those who study domestic contracts do so knowing that the shadow of the law is fundamental. Okay, so whenever private bargaining breaks down, there's always recourse to an existing set of courts. International law, on the other hand, is characterized by neither a set of long-lived institutions nor a shadow of the law. How then can we study international dispute resolution design? So the first thing, and this is getting to that special issue that I did in international organization, one way of getting at this question is to acknowledge that we can't take the enforceability of international agreements for granted because of anarchy. So if international law is going to provide any order for international politics, the law has to be what I would call an equilibrium in a non-cooperative game. In other words, it has to be self-enforcing. It has to be in the interests of the parties to sort of, you know, create this international agreement or institution, and there must be incentives for them to adhere to it for the medium run at least. Okay, there may be some short-term incentives to defect, but it has to be designed in such a way that it's better to remain in it in the long run. Okay, so this is this idea. This is why I draw on this kind of non-cooperative game theory, and that's just what I said, that it has to be self-enforcing, and that's kind of the essence of this rational design special issue, that you have to take into account the preferences of states and all of the constraints and design law with that in mind. And if you sort of through that kind of lens, we can identify, you know, sort of what kind of international law will be robust and what kind won't be, what kind will be effective, what kind will be ignored. Okay, so because we know that international law often does make a difference, but sometimes it doesn't. So when does it? And this is kind of the way that I look at it to try to get an answer. So just a few minutes on this rational design theory, since this is kind of the theoretical framework that I'm employing. The starting point is an empirical observation, just that institutionalized international cooperation is organized in radically different ways. So you have, you know, some two-page bilateral agreements, and you have other things that are, you know, very precise, creating, you know, intergovernmental organizations with elaborate voting rules, etc. Okay, lots of different ways that it's organized. The theoretical premise, and this is really the more important part, is that you can't understand institutional design and compare across institutions without understanding the cooperation problem the institutions or agreements, I'm using those interchangeably, are trying to solve. So I was actually invited, even though I don't know anything really about NAFTA, I was invited because of this work to kind of give an opening remarks at a NAFTA conference. And I noticed the night before at dinner, especially among the Canadians, that they were really kind of sad that NAFTA wasn't as deep and institutionalized as the EU. Okay, that was their perspective. Now, having looked at this continent, you know, a random sample of international agreements, if, you know, I were to sort of draw the spectrum of international agreements, NAFTA is way at the extreme, very close to the EU. It isn't the EU, but still, this is a very sort of institutionalized form of international cooperation. But why should NAFTA look like the EU? The EU, and this is what I said in the opening remarks, you have to understand the cooperation problem the institutions are trying to solve. Not to offend anybody here, but there was a German problem from the perspective of Great Britain and France when the EU institutions were formed. Okay, there was no such problem in North America. Okay, so some of the things that they're trying to do are the same, but a lot of the reasons that the EU was formed are completely, those problems are completely absent if we're going to analyze NAFTA. So there's really no theoretical expectation that they should be mimicking each other, that NAFTA should look like the EU, and that it would be more efficient and effective if it did look like the EU. So that's just kind of to sort of bring to life what all that this means. So what it implies then is that all these design variations that we see could very well be the result of rational propulsive interactions. And that's what I'm going to try to test here today. Okay, so these differences aren't random. So there should be some, you know, systematic explanation for that half and half empirical statistic that is, you know, noted in the title of the paper. And in this rational design, I don't have enough time to give you too much more detail about it, but we look at 5 aspects of design: what the membership provisions are, what the voting rules are, what the scope, the number of issues that are covered in the international agreements or law is, what the flexibility provisions are like withdrawal clauses, escape clauses, duration provisions, and the amount of centralization, that is some kind of delegation to a third party. Okay, that third party could be another state, it could be an NGO, it could be an IGO like the International Court of Justice, but centralization, you know, it's pretty broad, but here I'm going to narrow it down and think about centralized dispute resolution provision. And we develop a number of conjectures about when you're going to see more centralization. So one of the conjectures is that when countries are facing enforcement problems, they're more likely to have centralization, and so I'm narrowing that down here to delegated dispute resolution provisions. So enforcement problems, that is incentives to defect, when it's something like a prisoner's dilemma, when it, I would like all of you to cooperate, but I would really like to cheat while all of you are cooperating. Okay, situations like that are characterized by enforcement problems. When states are facing uncertainty about behavior, centralization is going to help. Uncertainty about behavior means you can't tell whether somebody's cooperating or defecting or not. And I'll give some sort of real-life international law examples of each of these in a second. When states are facing uncertainty about the state of the world, they're more likely to include some kind of centralization like delegated dispute resolution provisions. Uncertainty about the state of the world in everyday language is that you're not sure of what the consequences of cooperation are going to be. Okay, countries make a lot of international law, a lot of international agreements when there's scientific uncertainty, when there may be economic and political shocks that are going to change things. Okay, even exchange rate cooperation has uncertainty about the state of the world because you might have George Soros or somebody coming into the markets and changing things in a way that states didn't anticipate. Okay, so there's some problems that are characterized by this kind of thing. And finally, when states are facing commitment problems, this kind of centralization is going to help. Commitment problems, by that I mean, let's say you're a country like Bangladesh who's had a history of, 3 military coups in 10 years, and you want to encourage foreign direct investment, but you really don't know what's going to happen in your country given the tumultuous political history in the next 10 years. You may want to try to tie the hands of your successors through an international agreement. That would be a commitment problem, or what we call a time and consistency problem. Yeah,
Not to bring Chicago to Durham.
That's okay.
I had just a quick clarification. When you're coding for this, did you take account of whether individual states have reserved out of the dispute resolution clauses, which is fairly common, I think? For the U.S., I know in particular, the U.S. often signs on to treaties that have dispute resolution and then just reserves out of the dispute resolution part of the, or did you just look at the face of the treaties?
I looked at the face. I am coding for reservations as well. So that was something that actually came up last night that I need to sort of more tune that. But these, I'm thinking about some of the agreements in the random sample, like the San Jose Pact, which is the human rights arm of the Organization of American States. It does give jurisdictions to the ICJ. The U.S. didn't ratify it. So a lot of these, the U.S. actually isn't a participant. Yeah. So these are some conjectures. Now there's other cooperation problems. So I've highlighted these 4 kinds of underlying cooperation problems that I think would make states more likely to need dispute resolution provisions, centralized dispute resolution provisions. There's other problems that states are trying to solve, like encouraging positive externalities through scientific research, trying to prevent negative externalities. There's agreements that are trying to prevent, forest fires across, borders and things like that. There's a lot of cooperation, what I would call coordination games on standards and things, that once you figure out, how you're going to coordinate, there's no real incentive to cheat, so there's no enforcement problem, there's no real uncertainty about behavior that you can't tell whether people are cooperating. So there's, agreements can be divided into categories, and not all agreements are going to be characterized by these problems. So let me talk a little bit actually about how I'm going to operationalize these things and test these things. So the coding project is I'm drawing my sample from the United Nations Treaty Series, and there is a coding instrument. There's 2 undergraduates who have been trained for 9 to 12 months to read each agreement. So there's 2 coders for each agreement, and they fill out a survey that has potentially 375 questions that have a quantitative like answer, either yes or no, or some kind of multiple choice or a number. There's another 160 fill-in questions. So this coding instrument is potentially massive. but it isn't as sort of big as that for every agreement because it's designed as a survey. So for instance, if you're coding an agreement and it says, is there an amendment provision, and you answer no, there's about 10 questions that then don't appear. If you answer yes, you're going to be asked, how can an amendment get on the agenda? Who can propose an amendment? You know, does it take any, you know, subset of states, you know, in order to have a conference for the amendment? What are the voting rules for the amendment? Once the amendment is passed, is it binding on all states or only those states that voted on it? Okay, so there's all kinds of details that are asked about each thing, but if you answer no, a lot of these things, so if there's no reservations that are allowed, then you know, about 5 questions on what type of reservations disappear. So it's slow going because, you know, there's a lot of questions. I'm really having, you know, I have high standards in terms of intercoder reliability. So every time 2 coders complete an agreement, there's a report that gets generated that lets me know every time they disagreed on a question. There's never been a perfect agreement. So I'm going to present the results of an N of 88. Okay, so I have 88 sort of clean agreements in the sample so far. That means I had 88 meetings with these undergrads, okay? Just, you know, so this is like this thing that really I only add at most 5 agreements a month because, you know, I can only take so much of this. I have to do other stuff like teach and research, other research and all that. But this is kind of how the project is designed so we can have some faith in the data. But this is the stuff that I'm gleaning from the text of the treaty itself, what I would call the dependent variable, the design provisions, all that stuff that there's all this variation for. The underlying cooperation problem, like whether there's an enforcement problem, an uncertainty about behavior, whether this is trying to solve negative externalities, whether this is their goal is to try to spread a human right, a norm or something like that, that gets coded by a graduate student and myself. Because there has to be a separation between the coding of these independent variables and a coding of the dependent variables for there to be any integrity in my results. Otherwise, I know what my theories are, and I'm going to say, oh, there's this cooperation problem I need to find, or oh, I'm going to check and see that there's dispute resolution. So I'm pretty sure that's an uncertainty. And the biggest challenge is trying to infer the cooperation problem from the agreement, okay? Because the unit of observation in this whole project is an international agreement. And so what we do is we look at the countries involved in the agreement, we take a look at we do some background research about their history, we think about what the sub-issue area is, and so there's sort of obviously other things that inform it, because if you just look at the agreement, you don't know. The states may have been trying to solve something much bigger than that and they were only partly successful. So you try to get some background information about why the states were getting together, how they perceived the problem at the time. That's challenging because it's not, a lot of information is not sort of readily available for a random sample. Okay, some agreements you can find that out, the International Sugar Agreement, but if it's the African Migratory Locust Convention, it's harder to find out all this background information. So there is, you know, this is an imperfect measure, but, you know, the best I can do is document and justify, you know, why I coded each agreement. And so just to give you kind of a flavor for that and why I'm not just sort of looking and using sub-issue areas or issue areas as a proxy, I'll give an example, because I'm running out of time, 2 human rights agreements and how those are different in terms of how I coded the cooperation problem. So one of the agreements in the random sample is the Convention Concerning Equality of Treatment for National and Foreign Workers as regards workmen's compensation for accidents. Okay, and what that is basically it's states saying, you know, if this foreign worker has an accident in my state, he or she will have all the benefits that a domestic worker will have and vice versa, okay? So this is characterized by uncertainty about behavior. You can't tell. You can tell whether the laws are on the books or not, but you can't tell whether countries are really enforcing them. Okay, you can't tell when a foreign worker, absent any monitoring provisions and things like that, you can't just use, satellite technology and tell whether somebody who has an accident is really being treated fairly. Okay, so there's an uncertainty about behavior problem, which is actually, I find, for whatever it's worth, that about 40% of the human rights agreements have that kind of problem, where it's very hard to tell, unless you're on the ground, whether these human rights laws are really being enforced or not. It also has an enforcement problem. It is a prisoner's dilemma-like structure. I want you to give my workers great treatment if they have an accident, but I don't want to give your workers. I'd rather save money, and if your workers have an accident in my country, I'd rather just say, just go home and, you're not going to get anything, okay? So each country has an incentive. Each country wants the other countries to cooperate, but has an incentive to cheat, okay? So there's an enforcement problem there. Now here's another cooperation, another agreement, the International Covenant on Civil and Political Rights, that also has uncertainty about behavior. This agreement prescribes a number of civil and political rights that states are obligated to respect with respect to their own citizens. You can't tell, again, whether these are really being enforced. We don't know, for instance, if in human rights agreements like this, whether girls are really getting the same treatment in schools as boys are, and that kind of stuff, okay? So there is uncertainty about behavior, but there's no enforcement problem here. This is not a prisoner's dilemma type of setup. If you stop treating your, citizens well, okay, and you start defecting from the agreement, I suddenly don't have an incentive to defect, okay? I don't want you to defect I don't want to defect while you're cooperating. I mean, it just doesn't have that structure. So these are two human rights agreements that are characterized by a different combination of cooperation problems. And so this is just to give you, I hope, a little more confidence in my coding, that every agreement gets studied in that way, and it gets checked as to what kind of cooperation problem it has and it doesn't have. Okay. In terms of the, so those are the independent variables. I'm looking at the cooperation problem and then certain characteristics of the actors, which are more straightforward. The dependent variable here is dispute resolution. I'm kind of looking at it in two different ways. First, I look at, I divide the possibilities into four: informal. Probably don't need to, at a law school, I don't need to elaborate on these. So it's informal, mediation, arbitration, and adjudication. Okay, so these are the four ways that I code dispute resolution provision. I also look at whether there's delegation of dispute resolution, and I make a distinction between internal and external delegation, where external is to a third party, somebody outside of the agreement. It could be an IGO, it could be an NGO. You don't see that very much for dispute resolution. It could be a third state. Internal delegation is when a subset of the member states themselves are in charge. So if you think of Congress, there's internal delegation in terms of committees. I still think that's delegation. But it's not a third party. It's actually a subset of Congress that gets delegated to. So those are the, and I'll leave, anything for the rest for question and answers so I can just get to the results. So the first thing, and this is kind of the fun part of the project, after 88 meetings, it's fun to say, okay, what did the data say? Because we really don't know. So this is the statistic that motivates the paper, okay, the approximately half and half statistics about which agreements have dispute resolution provisions and which don't. But there's some very interesting differences across issue areas. So we see, and these are statistically significant differences. So we see human rights agreements are far more likely to have dispute resolution provisions, and environment and security are the least likely. In economics, it's about half. Okay, so these are, and now the next table I'm going to show you is only looking at column 1. It's looking at the 33% of the, it's conditional on having a dispute resolution provision. Okay, so for those agreements that have dispute resolution provision, this is what it looks like if you cut across the 4 kinds that I'm coding for. So what's interesting is that almost all agreements give states a chance to solve things informally. What's also interesting is that most agreements that have dispute resolution provisions mention multiple forms. That's why you wouldn't expect the rows to add up to 100. Okay, so let's say a typical investment agreement, bilateral investment treaty, looks kind of like this. It says, you know, states can try to, you know, talk things over. I don't know what the language is used, but, you know, friendly negotiations. Okay, so they try informal first. And if that doesn't work, usually in economics, it skips right to arbitration. And there they're actually given a chance to use internal delegation first. And if that doesn't work within a certain time period, which varies, but let's say it's on average 6 months, then it gets externally delegated. Any state can then go to the ICJ arbitration board or the World Bank or something like that. Sometimes that's specified. And so, you know, the easiest way of thinking, I mean, I'm personally not divorced, but we all know people who have gone through divorce. And I think everybody always tries to do it really nicely, informal. And then they go to mediation where somebody, just a counselor, helps them communicate, you know, because that's cheaper and doesn't, you know, become, then we try arbitration. And when that doesn't work, you go to the court, right? And so you sort of see in some ways international law resembling what people often do in real life when they're getting a divorce. And again, some interesting differences. Now, human rights, you know, there are 36% of them that don't really say anything about even doing the informal, friendly diplomacy first, that they go immediately to some more formal dispute resolution.
I just had a question on how you did the study. Is every international agreement counted equally?
Yeah.
So that the WTO agreement would be counted exactly the same as a bilateral double taxation treaty?
Yes, in this study, yes. And again, that is because I'm reacting to a literature that has almost solely focused on a few case studies. And so for me, this study is the random sample. This is trying to be, you know, I eventually will compare this sample to a sample of important international agreements. How I'm going to measure importance, I've got a few ideas. One is what scholars think are important. See what gets cited the most in JSTOR, in the law reviews or whatever. You know, then I'm not going to get arguments from my colleagues about, well, you left out this agreement. It's like, well, this is the one that, you know, try to find the 20 agreements in each issue area that get written the most extensively about. But they could also be, there's other ways of mentioning, you know, through the scholarly, asking experts, looking at citations in the press or whatever. But yes, everything gets counted equally here. Yeah.
So you have one for all UN treaties as well, the way you have one for the WTO.
So it's what the sample's coming from the United Nations Treaty Series, which has everything registered with the UN from its inception, but also actually has quite a few League of Nations things going back as well. I'm going to enlarge the sample at some point because now there's a whole other historical database. And also this particular database unfortunately stops. When I drew the random sample, the United Nations only had up through 1985, I believe, online. So I'm missing the last 20 years, which will be quite interesting to see if the role of non-state actors, and because I'm coding for all that kind of stuff with 300 questions.
In the WTO you have like 40 agreements. You count those as one.
If that, I see what you're saying. The UN doesn't. I mean, I haven't looked into, because the WTO wasn't around when I drew my random sample. So for instance, the international, this might help explain a somewhat comparable situation. The International Labor Organization is an organization with headquarters, but they generate under their auspices a number of human rights treaties. That's how they're categorized by the UN. Numerous ILO treaties can come up in the database. Okay, so I'm counting treaties. The agreement is the unit of observation. I am asking whether it's created under the auspices, so that if there's a problem with that and these shouldn't be considered independent observations, we can control for that. We can see that all, you know, these 5 treaties in the random sample were all created under the auspices of the WTO or the ILO or whatever. So the data set will be flexible that way if you know, that's like a good point you raised about the independence of the observations. So those are, it's just kind of fun, again, to see what the descriptive statistics actually look like. And then, the external delegation too. So again, these are conditional on having dispute resolution provisions. And so there we see that economics agreements are the most likely to use external delegation to some third party, and security agreements are the least likely. And I think this kind of goes with our intuitions, at least in international relations, about security versus economic cooperation. And then very, very briefly, so I've got these hypotheses that, so then I code the agreements if they have one or more either enforcement problem, uncertainty about the state of the world or behavior, or a commitment problem. And if they have at least one of those things, they're considered having a complex cooperation problem. And so I'm now running the sort of statistics to see whether agreements that solve complex cooperation problems are more likely to have dispute resolution provisions. And I also do that for the delegation. These are just some cross tabs. Let me get right to the Probit analyses. I don't have many control variables in this. So this is, I have an article right now in the APSR that's a little, I mean, that was the sort of culmination of my work on flexibility. This is the first piece on dispute resolution. So this I would argue is a little bit preliminary. But I'm controlling for, you always have to control for power if you're in international relations. You just can't get anything published if you don't have a power variable in there. And so I'm looking at, we should expect a positive relationship between having a complex cooperation problem and having dispute resolution, and we do see that. So, and we see that the variable, the coefficient gets larger and more significant as we narrow down dispute resolution and exclude, this excludes informal, and this excludes mediation as well. So this is simply adjudication and arbitration. This includes mediation, and the first column includes everything. Okay, and we also see that you're much more likely to externally delegate when you have a complex cooperation problem. This power variable is not significant except in the first case, and it's very counterintuitive. This is basically saying that when the US or the Soviet Union are involved, they're less likely to, in some sense, use informal dispute resolution, because that's what's driving, in some sense, column 1 versus the rest of the columns. And this is a nice result, too. This is just kind of a transaction cost argument, that as the number of countries involved in the agreement goes up, the more likely you're going to have some kind of centralized dispute resolution. So you're going to see it much more in multilateral agreements than bilateral agreements, which just kind of, again, just is a sort of efficiency thing. So I think I better just kind of wrap it up. Let me turn this off so that it videotapes better. Never been videotaped before. I have another statistical table with some what we call deprobit results, which are much more intuitive, but we'll leave that. So for me, this work just adds to a body of work that informs the debate on whether international law can help order world politics, okay? Because that's still a lively debate in political science. So I started out asking which half needs explaining. In fact, I don't think neither half needs explaining, okay? We should expect to find dispute resolution provisions only in agreements where they're likely to be used, which are actually solving tougher problems. If you're trying to coordinate on scientific cooperation, you're probably not going to cheat. You're not going to be worried that somebody else is cheating because you can't tell or whatever. And so essentially, different cooperation problems imply different needs for dispute resolution provisions. Okay, so this is just kind of going back to that whole rational design, that agreements in international law are designed to help states solve specific problems, and that's why we see the variation. The other thing I like about the result, though, is in some sense, you could interpret it as calling attention to the efficiency of international law. Because in domestic law, I don't know, so you would know this, but I imagine lots of contracts just kind of mention what's going to happen automatically if there's a dispute. You just have this existing set of courts that you can take for granted, okay? In IR, in international law, you don't have that. You have to sort of create dispute resolution authority. You have to delegate, okay? It's not just there waiting for you, okay? You actually have to sort of be proactive about it. And so if you don't think you're going to need it, why delegate authority, okay? And that may be what we're seeing. And it's kind of, for those of you who know the law and economics literature, it sort of suggests the relevance of the law of economic organization, kind of Coase's 1937 stuff about firms versus markets, that you only transfer things into firms up to the point where it's beneficial to do it. Otherwise, you leave it to the market. You can kind of think of real deep international agreements with lots of provisions for everything as being more firm-like, while those that are really sparse are kind of more like the market. They leave a lot of things up to the states, okay? So you just don't incorporate things into the international agreements if it doesn't sort of, if the benefits aren't going to outweigh the costs of doing so. And then it also just encourages us to broaden our perspective when we're thinking about international agreements, international law. So for a long time, the field in international relations, at least, was fixated on multilateralism versus bilateralism. Okay, there were like 3 or 4 books written about that, edited volumes, etc. There's tons of other ways of cutting, you know, of sort of analyzing and dividing up international agreements. We can look at those. I've looked at which have finite durations and which have indefinite durations, which have escape clauses and which don't, which have dispute resolution. Later we can look at which delegate externally and which don't, okay? There's just this lots of ways of cutting up the universe of international law that might give us some perspective on international politics. And so for me, I mean, this is just more evidence that it's kind of silly to keep arguing about whether international law matters or is meaningful. It obviously can be. That isn't to say that, you know, I'm focusing on design. Okay, I can't tell you how effective these are. I can't tell you how often these dispute resolution provisions are actually used. There are people who have looked at that, like in the WTO. And they're getting sort of positive answers, positive in terms of if you think international law matters. But you know, all I can say to the realists out there, or you know, the Eric Posners of the world, or whatever, is that you know, if these things just really don't matter, then why do states continue to spend a lot of time negotiating about details of international law, and why are the patterns so systematic? If they didn't matter and they're never used, why wouldn't the patterns just resemble noise? You know, there's still something very systematic, you know, going on. And so we can only know through case studies how effective they are. But I think these larger end studies that show the systematic design still could help us jump to the conclusion that these things probably matter. Okay, I'll take questions.